Well, good afternoon, everyone, and thank you for joining us for today's Philanthropy Roundtable webinar, Protecting Our Individual Rights, What Should the Supreme Court Weigh In On? I'm Debi Ghate, the Roundtable's Vice President of Strategy and Programs, and I want to welcome you. So here at the Roundtable, we support the philanthropy of generous donors who want to see more liberty, opportunity, and personal responsibility in the world. They and we want us to have a stronger, free society. So to do that, we offer programming that helps highlight important organizations and thought leadership that positively impacts the elements of a free society. America's founding principles, which provide us with a common framework from which to continually improve and progress and grow as a nation. Pathways to opportunity, which means removing obstacles, often government created, out of the way of people who want to pursue life, liberty, and happiness. And also strong communities, the backbone of what keeps a free society flourishing. So philanthropy plays a critical role in all of these areas, and we are grateful to all the donors whose vision makes this possible. Today, I will be joined by two friends who've committed to ensuring that all of us have the liberties accorded to us by our Constitution. When Congress, the administration, state, or local governments overstep their constitutional authority and violate the rights of individuals, it's up to the courts to correct these actions. And they can have devastating consequences on individuals and businesses and families. So the Institute for Justice and the Pacific Legal Foundation are two public interest law firms that do just that. They work to protect the individual rights of people. They are similar, but different. What they have in common is that they are fighting to preserve liberty and opportunity for all Americans. So I'm going to ask Stephen and Scott to please join me now. And by way of quick introduction, Stephen is president and CEO of the Pacific Legal Foundation, founded in 1973. PLF litigates cases nationwide to vindicate the rights fundamental to a free society. With the Supreme Court appearance as recent as this March, which we will hear about, PLF fights on the front lines, preserving the American ideals of individualism and liberty. Welcome, Stephen. Glad to have you here.
Thanks, Debbie.
And also we have Scott Bullock. Scott joined the Institute for Justice at its founding in 1991. And in January 2016, he became its second president and general counsel. IJ pursues strategic public interest litigation that combines courtroom advocacy with media relations, activism, and strategic research to secure constitutional protection for individual rights. So welcome, Scott.
Great to be with you, Debbie.
So let's get on with this conversation because there's definitely a lot to cover. You guys ready?
Ready.
Let's go.
Okay. Well, here's one question I want to get out of the way, because I know that people are probably wondering, based on the descriptions that I read, that there seems to be some similarities between what your two organizations do, but there are also differences, right? Attorneys seem to move in a friendly manner between your two organizations, which is always great to see. But the reality is your two organizations are really complementary. Rather than competitive or duplicative. And I was wondering if we could start there, right? What are the issues that each of you takes on? Because there isn't all that much overlap. So what types of issues does IJ take on? What type does PLF take on? And why don't we start alphabetically with Stephen? Stephen, what issues do you take on at PLF?
Sure, we handle 5 or 6, depending on how you count, separate issues. We do economic liberty, we do free speech, we do property rights and environmental law. We also do equality before the law, discrimination related cases, and then what we call separation of powers, using the architecture of the Constitution to strike down against the 4th branch, the administrative state. So those are the essential similarities, the essential things that we do. And if I could just mention, I look at our organizations as kind of an orchestra. If our symphony number 1 is individual liberty, well, someone's got to play the woodwinds, someone's the brass. We may have different strategies, different areas, so we play different notes or instruments. But at the end of the day, we all have to come together because our enemies are legion, unfortunately.
I love that analogy. Thank you, Stephen. So starting from symphony number one, what does IJ play in the whole individual rights litigation
I
area?
guess I have to come up with a jazz analogy now for it. But yeah, so IJ has always been founded on our 4 pillars: economic liberty, property rights, educational choice, and free speech. Those are kind of the hallmarks of the American dream, rights that most Americans understand and consider important, but have been woefully underprotected by the courts. And even though, for instance, like PLF and IJ both do property rights, we do have these distinctions. PLF has always been a leader in the field of regulatory takings, for instance, and we've done amicus briefs in that area. But our focus on property rights has been on challenging eminent domain abuse, which we did for a number of years. And now we've been challenging the abomination of civil forfeiture. And now we've also expanded into what we call abusive fines and fees schemes, or taxation by citation. So those are areas that have always been the core of our work. We've expanded recently into an area that touches on really all 4 of our pillars, and that's the launch of our project on immunity and accountability that we just started in 2020 to try to challenge these outrageous immunity doctrines that insulate government officials from any sort of accountability. And all of our work, we're trying to better protect property rights, better protect constitutional rights, expand opportunity for all Americans, and to try to create a more free and just country.
So thank you, Scott, and thank you, Stephen, for explaining that. I mean, the bottom line is there's actually so much that requires attention that it does require a whole orchestra, as Stephen said. And I hope that, distinction will be helpful for our audience in terms of just what IJ focuses on, what PLF focuses on, and why it is you're able to work so well together. So that was very helpful. Now, both of you are going to be talking about Supreme Court cases that your groups are involved with. And in fact, one of the exciting things is right now, you're actually waiting to hear whether or not the court will take on some of the cases that you've petitioned them to hear. IJ has 4 of those, and PLF, I think, has 7 of those, right? So we're all sitting here on the edge of our seats, waiting to know if you'll be able to appear in the Supreme Court soon. I'd like to hear from each of you before we start getting into the details, right? What makes for an ideal case to take up to the Supreme Court? Because certainly there are probably hundreds of thousands of cases, right? So what's the ideal case to take up? And Scott, I'll start with you this time.
Sure. I mean, you're always looking for a cutting edge legal issue, simple, outrageous facts, sympathetic plaintiffs and clients, and evil villains on the other side. Those are kind of the hallmarks of a great case in general, and certainly a great Supreme Court case. The other thing, too, that the Supreme Court in particular looks at are issues of national importance, too. And that's one of the reasons why IJ and PLF and many other public interest organizations don't just argue cases in the court of law. They use all the other tools of public interest law, media relations and grassroots activism and strategic research, to show that this isn't just an isolated example in this particular area, but this represents a nationwide problem. That always interests the Supreme Court. And then the court most likely takes up cases where there are splits of authority, where state Supreme Courts and federal circuit courts of appeals have come to differing conclusions on provisions in the Constitution or on statutes, and the Supreme Court has to step in to decide what this provision of the Constitution means, or whether this statute is constitutional. So that's one of the reasons, too, why we don't do one-off cases. We have a number of cases in particular areas because you're trying to build that authority, probably get split decisions, and then at a certain point, elevate that issue to the Supreme Court.
All right, well, some of this is going to come up in our discussion, this whole issue of having a series of cases on one issue. This is going to come up. So thank you for that. The first part of it sounds like I was listening to you and I thought, geez, that sounds like it would make anything that would make a really great, compelling movie is the kind of case that you want to try to get. And then it has to be on the right kind of issue with the split of authority. Okay, Stephen, what about you? Is there anything that you would add or differ from Scott on in terms of what makes for the ideal case to take up to the Supreme Court?
One thing I would add is, for groups like PLF and IJ, we have such a body of work now since we've been around for so long and have had such success both in the courts of appeals and at the Supreme Court, that because we're working incrementally, what we also do is look for cases that go just a little bit beyond a case that we may have litigated before. So for instance, our first Supreme Court case that PLF won back in 1987 was a case called Nolan versus California Coastal Commission. And there have been a series of cases that have taken that law a little bit farther. And by farther, I mean for the benefit of property owners. And we had a case just a couple of years ago called Kuntz, which is an extension of those. So I think we're also looking not only to engender the circuit splits, but also to look at those issues that where we've had success in the past and try to extend them even more, which is why what Scott said about the clients is so important, because when you're fighting against what is often decades of bad precedent, you want to give judges, who are human beings after all, a reason to rule in your favor, and that often gives them that reason.
Yes, this series of incremental progress. Law is very rarely one fell swoop, and much more about building the right legal precedents and then incrementally improving them. All right, so we've got a lot of experience between the two of you to being in front of the court and arguing the cases. I want to hear what is one thing that each of you thinks people should know about the Supreme Court? So when you think about the court and its role and your experience there, what's one thing people should know? Stephen?
I would actually say that it's not as divided as the media might make it seem to be. We've had 12 wins at the Supreme Court. 6 of those wins have been unanimous. And we're a very ideological organization. And one might expect that we wouldn't be able to get folks particularly on the other side. But I think, as you saw with Justice Breyer earlier this week at a talk before at Harvard, saying, don't pack the courts because we're not a political animal and you would lose trust. So I think we have to understand that the people on the court, they actually like one another. And while they may disagree philosophically, it's not through a partisan lens necessarily. And I think the way that we can construct cases to try to make it so that they're not all 5-4, which are the ones that get the most attention, but are actually very few of the decisions that come through every term, the better we'll be as a movement as we go forward.
And the more certainty we'll have about what the law actually is, right? And this is, I think this is something that if people look at the statistics, it'll bear out what you're saying, Stephen, actually looking at how the decisions are made and the numbers. Scott, what do you think is one thing, some people should know about the Supreme Court?
Yeah, I mean, I agree with it. On a lot of the issues that we litigate, there's these interesting possibilities of cross-ideological alliances, both on the court and even among citizens then too, and that's always great to see. The one thing I think people ought to know is that the Supreme Court is not really about what's called error correction. So they'll sometimes do that, but lots of people feel like, I'm going to take this to the Supreme Court because the decision below was wrong. They are really looking for these issues, as I said, of national importance and where there's been these splits of authority. That's what's going to get their interest, and not just kind of correcting a bad decision below. And so that makes it all the important, as I said, to use these other tools of public interest law and to try to develop these circuit splits. The other thing too that the court is very interested in doing, you see this coming up over and over again in cases, and something that lawyers have to be very prepared for, is line drawing. That's what the court isn't really even sometimes interested in the facts of that particular case. They want to know what this broad ruling might mean for people in other situations. So that's why attorneys that appear before the court get endless hypotheticals given to them. What about this? What about that? And you can't say, well, that's not this case, Your Honor. That's the worst possible thing you can say before the Supreme Court, because they want to know the real impact that this decision is going to have.
And a surprising number of those hypotheticals involve cars from what I have seen and heard. Yeah, different types of cars. Okay, so now let's get into some of the cases, because I think one of the things that strikes me is that most members of the public probably aren't following what the Supreme Court is hearing day to day, when they are sitting and hearing cases. we hear about the big ones. There's some that make the news, but there are a lot that don't. And I think it's important because of the kinds of decisions the court is making for people to at least think about the issues. So you've got some cases that are active. And Stephen, your team was last at the Supreme Court on March 22nd. So very recently, and you were arguing a case called Cedar Point Nursery versus Hasid. Can you tell us a little bit about what that case involved, why it's important, and what it was like at the court?
Sure. Well, this is a kind of a classic PLF case. This was the 15th case we've had before the court, and 13 of those cases are on property rights, and this is exactly one of those. And this is a situation where we represent a farmer named Mike Fonner, who owns a nursery in Northern California. And there's a particular law here in California that allows union organizers access to your property 3 hours a day for 120 days a year. Well, that's a classic easement. It's time limited, but it's still a physical invasion of your property that prevents you from using what is your right to exclude people from your property. We think that is a taking under the Fifth Amendment, and that was what the case was all about. Now, interestingly, this case started 6 years ago, so it shows you how long it takes for these cases to bubble up to the Supreme Court. In fact, it took almost a year and a half to get the Ninth Circuit to rule on our case back in 2017. But the argument was interesting, and it reflects two comments that you guys just made. One is cars, and one is line drawing. This is a classic case of line drawing. We believe that when you have a time-limited access availability to a third party, that is a taking under the Fifth Amendment as a per se matter. It's categorically a taking, which means the government then owes compensation. The other side believes that no, we need to use an ad hoc balancing test under this thing called Penn Central. In fact, Penn Central is mentioned 25 times in the argument, but even the more liberal justices weren't buying that because they didn't believe that you should have this not for it to be essentially up in the air about whether it's a taking. So there were lots of questions about where you draw the line. We think it's a pretty clear line. The Solicitor General for California tried to muddy the waters by bringing this Penn Central thing and saying, the world's going to end if you allow their rule. And Justice Breyer, of course, had a crazy hypothetical this time about space cars. And what's interesting about how arguments are going these days is they're not in person; they're over the telephone. And not even Zoom. It's just a good old-fashioned telephone, and it is mapped out before the arguments just how much time each of these justices have. And Scott, can attest from his own arguments what it's like to have a Justice Breyer hypothetical, because they can go on for 7 minutes, and you only have 30 minutes to argue in the first place. So the fact that he had 3 minutes to get his space car hypothetical in, and then was cut off to go on to the next justice was actually a good thing, we think, in our case. And, cases go to the Supreme Court because they're difficult. There's no doubt about that. We think we presented a good reason for them to rule in our favor. I'll knock on wood, we'll get our 13th win, and I'm cautiously optimistic that that's the case. And we'll know by the end of June what actually happens. But, I will say that I was very heartened by some of the questions I saw from folks like Justice Sotomayor. And interestingly enough, for Kavanaugh and Barrett, they don't have a long record of jurisprudence on property rights issues. So this is kind of the first case we'll find out just how meaningful they believe the takings clause of the Fifth Amendment actually is.
Interesting. We'll be following that. Can't wait to read the decision. I think
or decisions. Possibly.
Yeah, that's true. I should not assume decisions. I think one thing that people might find interesting is just how much property rights have been under attack and undermined over time. And sometimes if you're in law school discussions, there's even a question of whether there is such a thing as property, right? So I applaud you guys for taking that one, and we'll look forward to the decision. All right, so Scott, mentioned that you were waiting to hear about 4 cases as to whether they'll be taken up by the court. One of those is about school choice. And I want to talk about that one because during our K through 12 virtual summit that we did in February, we had your lawyers on talking about the Espinoza case, which was the last major decision in school choice. Now, one of the issues that came out during that panel, and I think it's an important point, you've already touched on it. A win at the Supreme Court does not mean the issue is forever resolved or forever completely dealt with, right? A lot of work that needs to be done to implement a decision in various places. There are usually follow-on cases that come to clarify and or extend, right, the law. So you have a case in Maine. Tell us about that case. How does it build on what happened in Espinoza?
Yeah, you're absolutely right, Debbie. Oftentimes it takes follow-up litigation to both enforce Supreme Court decisions. Brown versus Board of Education is a classic example of that. Landmark decision from the Supreme Court striking down separate but equal. But it wasn't like every state then said, oh, okay, I guess we'll just follow whatever the Supreme Court told us. It took a lot of rounds of litigation to implement that decision. And that's true in a number of different instances. It fundamentally changes the law, but you have to build upon that. And so, yeah, the Espinoza decision, which we won last year, was our third decision victory at the Supreme Court on educational choice. And what we've been doing really since our founding is being the lawyers for the educational choice movement. And we do 2 things. One, we advise legislators to bulletproof the programs as much as possible when they're being passed, because we know the inevitable attacks are going to come from the teachers' unions and their allies. So it's important to get the programs as sound as possible. And then once the program is challenged, we intervene in the cases on behalf of the true beneficiaries of the program, parents and kids. And so we've been really clearing the way for the constitutionality of school choice since our founding. We won a major victory that removed the largest federal constitutional obstacle against school choice back in 2002 in a case out of the Ohio educational choice program, where the court said it wasn't a violation of the Establishment Clause of the First Amendment to have choice programs that included religious schools among the range of options, public, private, secular, and private religious, that might be available to families. And then just this past year, we won the Espinoza case, which removed the largest state constitutional barrier to educational choice in the form of Blaine amendments, which are amendments that exist in over 30 state constitutions. Probably many listeners have heard of those. They're out of the relics of 19th century anti-Catholic bigotry. For it. So they have a very nasty pedigree. And the Supreme Court, this was a 5-4 decision, said that Blaine amendments cannot be applied to exclude religious options. But the opinion was written by Justice Roberts. And Justice Roberts has a tendency to decide things narrowly. And so what he said in our case out of Montana was that the tax credit program there was discriminating based upon what religious status, simply that the schools were religious, therefore they could not participate in the program. And he said, we'll save for another day the question of religious use. And so that would mean if the religious schools participating in the program actually were somewhat religious, which is kind of the point of being a religious school. And so we had a case in Maine where Maine and several other New England states, the villages there are so small, they don't have a public school system. So they tuition kids. It's actually a robust school choice program. They tuition kids to go to a public or private school of their choice in another community, with one exception. You can't use it at a religious school. And so after Espinoza, we think that that is just blatantly unconstitutional. We challenged this. We were doing this case actually even before Espinoza was decided, but we had an unfavorable panel with the First Circuit, which is the circuit that covers out of New England, and they latched on to this language in the Espinoza decision and majority opinion by Justice Roberts about the status use distinction, and said, oh, the schools here might be using these funds for religious purposes, therefore Espinoza doesn't apply. So we then have filed a cert petition to say, now you do have to address this, or you should address this now, to stop this kind of loophole from expanding. So we're hopeful that the court takes it up.
Did you include a cover note that said, "Dear Justice Roberts, thank you for the invitation"?
That was kind of the undertow
Yeah.
of the entire petition.
Excellent. All right. Well, Stephen, PLF actually has 7 other cases that you're waiting to hear on, right? But you've heard on some, and you've had a couple of your certs denied, right? Your petitions denied. And I wonder, you had one that was denied around a home equity theft case, and home equity theft sounds like this abstract, intangible thing that's now being stolen. And it actually sounds awful. So I'm wondering if you could tell us about what the home equity theft issue is, why it's important, why you think the court should take this one on in the future, and what happens when your petition is denied. What happens next?
Sure, thanks. So home equity theft is is when, then about 15 states have these laws where if you have failed to pay your taxes and your house is foreclosed upon, the government will sell the house, take the proceeds, and keep them all. Not just keep what you may have owed in taxes and penalties, but keep every red cent. We had a case before the Michigan Supreme Court, which IJ wrote an amicus brief in support of, where we wanted the Michigan Constitution, saying this is a taking under that state's constitution. And this was a situation where a guy named Yuri Raffaelli underpaid his taxes for for $8.41. And they kept tens of thousands of dollars in proceeds as a result of that foreclosure. So we have taken up a number of different petitions, and this is what happens at the Supreme Court. You don't quite know why they take your particular case at that time. So we're continuing to knock on the door to try to get them to rule in our favor on either that it's a taking under the Fifth Amendment or that it's an excessive fine under the Eighth Amendment. And this would be an extension of a case that IJ won a couple of years ago called Tim's. So it's a important issue for us. I think it's an important issue for a movement. When you don't get the petition granted, you just find another case that might present that same issue. At PLF, we have a number of questions presented across all of our practice groups where we're constantly looking for cases that might present that question to the court. And we will often take cases over on appeal. So instead of bringing them from the trial court, we'll take them over on appeal, often after having filed an amicus brief in an appellate court for that particular client. And we had a case called Feltner, another one called Barnett. Both of them were denied. And then there are other interesting issues beyond home equity theft where we've gotten a denial of cert, but an invitation from the court to bring another case. And this happened in a case out of Massachusetts on behalf of the Lobstermen Association. And there, as President Obama was leaving office, he designated an area the size of Connecticut of the Atlantic Ocean as a national monument. And people might think, well, a national monument, well, that should be land. Well, that's exactly right. It should be land in the United States, not stuff that's underwater or an ecosystem in this case. So we were challenging that as a violation of the Antiquities Act. And it's a ratchet that presidents have. To do a national park, you have to have congressional authority. But under the Antiquities Act, the president can just designate some land, and then it is a national monument, and it's off limits to lots of uses. And what's interesting about this one is, even with the denial, the Chief Justice filed a statement saying, while this case is not quite the one we want to take, the denial is not a decision on the merits. So please bring other cases like this, because we would like to finally decide this, because the area of law is so muddy right now.
Again, dear Chief Justice Roberts, thank you for the invitation.
Take more cases than you do right now, because they're doing a decreasing number of cases over the past few years.
Yeah. And this is, I encourage people, if they come to DC, to go and actually visit the Supreme Court and do the tour there, because they will sit you down in the courtroom and walk you through, how they choose the cases, where those decisions are made. And it is fascinating. Just a plug for actually going to the Supreme Court yourself. All right, so Scott, you mentioned that you're working on a newer issue around qualified immunity. And I know IJ started taking these cases on and thinking about this issue before qualified immunity became a topic of public conversation following George Floyd's death. And suddenly you were seeing it on placards and in the streets. So the court in 2020, if I remember, they turned down the opportunity to hear a couple of cases around qualified immunity. And it's tempting to speculate why and all of that. And you guys have been wonderful in teaching me not to do that, not to do that speculation. But why? So why is this issue important? And you have a case now that is, again, waiting for a decision. Will the Supreme Court hear it? Why should they hear it? What is it? Tell us about that.
I mean, it's an incredibly important issue, and it touches upon so many of the issues that we litigate and others do. And it's really this judge-made doctrine. And this is what it really is. It's not in any statute. Judges have devised these immunity doctrines. Qualified immunity is probably the most prominent one, but there's other types too of absolute immunity that oftentimes prosecutors enjoy. And then this also arises in the context of what's called Bivens actions. And that's what the case that we have currently before the Supreme Court goes toward. And it's an outrageous case where some federal police officers in El Paso, Texas, in a veterans hospital, in a security line, there was a kind of a dispute about a veteran who was going through there, and he was attacked without provocation and choked and severely hurt. And so he said, my rights have been violated. I want to hold these officials accountable. And what happened in this case is even a step beyond qualified immunity, because qualified immunity typically attaches to state and local officials. It also applies to federal officials as well. But when you talk about federal officials, there's a whole other level that you have to get through, and that is making sure that you can have a Bivens claim based upon a case from 1971 at the Supreme Court. And the Supreme Court, over a series of decisions since that time, has made it extremely difficult to hold federal officials accountable. A lot of hurdles for state and local officials, but there's even just added ones for federal officials. And so your rights are violated without a remedy. And that is contrary to its fundamental notions of American law from the time of the founding. And so there's been a lot of attention on this issue. Judge Willett, who many of the listeners might be familiar with, a judge out of the Fifth Circuit, has been talking about this issue and has made it very clear that federal officials can violate rights, at least in the Fifth Circuit, Texas, Mississippi, and Louisiana, with impunity now. And he wrote an opinion in another case, citing our case called Aliva, that's currently pending before the Supreme Court, basically begging the Supreme Court to do something about this. He said, listen, I can't do anything about it. I'm just he called a middle manager. I'm on the circuit court. But you ought to take up this issue because people's rights are being violated without a remedy. That happens in the qualified immunity space, and it is even more, in some ways, egregious in the Bivens context. And so we filed this petition, had a lot of great amicus support, and are making the argument that I think is going to have appeal across, again, ideology on the Supreme Court, that Bivens was not just made up by the Supreme Court in the 1970s. The right of federal officials to be sued by citizens in either state or federal court was recognized from the time of the founding throughout most of the nation's history. So we're hopeful that the court does something about this. I think they're going to take up one of these immunity issues. I mean, the speculation is that maybe the issue was a little too hot this past summer, and they said, so we want these passions to cool down a little bit on this. But the facts of them are outrageous, and the Supreme Court, because the law is so bad on this, is going to have to take this up. And again, you have some interesting cross-partisan alliances, because the two biggest critics of qualified immunity on the Supreme Court are Justice Sotomayor and Justice Thomas. They usually don't agree on very much, but on this issue, they're united and are saying that the court has to address this.
Oh, wow. And it's ironic that you're waiting for the decision about whether they'll hear the case as the Derek Chauvin trial has started, right?
That's
So,
it.
I
And if
mean,
they don't take this, we have this whole project we just started last year, but has really gotten a lot of traction. Unlike occupational licensing and eminent domain and civil forfeiture, where it took years for us to gain a lot of attention for, this is an issue that has really rocketed to the national consciousness in a way that few anticipated. So hopefully they'll take up this, but we've got a lot more in the pipeline if they don't.
all right. All right, very important issues. All the cases we talked about involve, yeah, they're questions that actually affect everyday Americans as they go about their lives, whether it's their child's education, whether it's trying to run your nursery and you've got, you know, stampedes of people coming across it. I mean, every one of these cases affects the lives of everyday people. So thank you for doing those cases and making sure we're protecting those rights. I want to move to questions now from the audience. We have some, so let's see. Well, here's an interesting one. So when we talk about protecting constitutional rights and individual rights, I'm not surprised that we've got someone out here thinking about the ACLU and asking about, will they return to protecting civil liberties the way they were once known for doing? Do you have any thoughts on the ACLU? Do you have partnerships with them on some certain issues, et cetera?
We do actually work with them on certain issues. Civil forfeiture, which I mentioned, is a big part. We have another petition pending in that area. Stephen was talking about statements that were made about on issues by certain justices. Justice Thomas just recently did that on civil forfeiture, saying we have to address that. We hope our case is one of the ones they're going to address it on. So in certain areas, we have worked with them. And when they stick to traditional civil liberties issues, they can still actually do good work on Fourth Amendment rights and challenging government surveillance and that sort of thing. And they're interested in curtailing immunity doctrines and that sort of thing. But I think they've done what happens sometimes, and it's a danger of nonprofits, is to have real mission creep and to then start going off and doing a lot of other cases that really aren't certainly about civil liberties and are about matters that people don't really understand. Why are you getting involved in this, especially when there's so much work to be done in the traditional civil liberties area? So we work with them on areas of mutual interest, but I wish they would be even more focused on things that are vitally important to the Constitution.
That makes sense, Scott.
If you were to go to if you go to their website and pull down on their issues, you know, it's a litany of different types of things, and you would wonder, as Scott said, you know, why are you doing that? You know, our experience has been a little bit different. In our quality practice, for instance, we've often been on the other side of the ACLU, where we're trying to prevent government benefits or burdens from being placed based on characteristics. The ACLU is just taking a different tack, and it's an identity-based one as opposed to an individual-based one. So I'm not hopeful or very sanguine that they will get them on our side on those things, but we do look for places beyond just the ACLU and other kind of cross-ideological instances where we may not see eye to eye on everything, but on certain things you might, and in those cases we do want to work together. Yeah.
And certainly a very important organization in the history of individual rights in the country. So I appreciate your comments in terms of the present situation. Okay, so here's a question that is getting into criminal law. Now, neither of your groups does a lot of direct work in criminal law, so I want to preface it with that. So if this is one that you want to put to the side, no problem. The Sixth Amendment guarantees the rights of criminal defendants, including the right to a public trial. And of course, this person is asking about the number of situations where defendants are foregoing the trial, not getting a trial, and they're dealing out, right? So he says 96% of federal criminal cases are plea bargained with no trial. In the early 1800s, it was the other way around, right? 96% went to trial. So any thoughts on the Sixth Amendment? And we did a webinar on a documentary called The Vanishing Trial, which was exactly about this issue. So people can also check that one out. Do you guys have thoughts on that one?
I'll just say a couple things about it. I think he's absolutely right that this is a real problem. Our friend Clark Neely over at Cato has been writing about this a lot and doing a lot of great work showing what a problem this is for criminal justice. And we do do issues that touch upon criminal justice. A lot of our fines and fees work and civil forfeiture, and obviously the immunity work does as well. The big problem here, and one of the reasons why there's such this push to do plea bargaining and that sort of thing, is just the massive growth of criminal law at the federal level and at the state level then as well. And so you have so many things that are crimes today, and prosecutors have so much discretion to throw so many things at you that you really have this need oftentimes to plea bargain, because the alternative to it, if you would happen to be convicted, is so dramatic, and you could spend the rest of your life in jail, that the system kind of pushes you toward it. So the real solution to it is to cut down on the amount of things that are crimes in this country, and to rethink how we're doing things in the criminal justice system across the board.
Yeah, I agree with you, Scott. Stephen, do you want to add to that?
Well, I think just the spotlight that's on the criminal justice area these days is a good one to have, to just kind of peel back or look behind the curtain of what is actually happening. You have discussions of bail, for instance, bail reform, and the fact that the longer you're in jail because you're too poor to pay for bail, the more likely it is, the longer you're going to spend in prison, and the more likely you are to be convicted. So I think while I might not agree with all of the proposals out there, the idea that we should take a hard look at how that system operates, I think is ultimately a good thing.
Okay, well, we are actually coming to the end of our time already. Can you believe that? This went by really quickly. I wanted to give you a chance to make a closing comment. I like asking at the end, what's the one thing you hope people will take away from a conversation about the Supreme Court and its importance? So, Scott, why don't I start with you? What's one thing you hope people took away from today?
Well, I think that people should take away the importance of the issues that the court deals with. These are vital issues that impact people's everyday lives. When we did the Kelo case, that was one that resonated so strongly with people, because folks looked at Suzette Kelo's little pink house and said, that's my house, or that's the house that I want to live in someday. So it really hit home literally to so many different people. And that's true of so many issues that the court addresses. It's one of the reasons why people ought to pay attention to the courts and to take seriously the rights that are at issue when anytime the Supreme Court weighs in.
Thank you, Scott. And Stephen?
I would say that we have to remember that the judiciary is a third co-equal branch of government. And while it's important to focus on the other two, the third branch is the bulwark of liberty. It's the one that stands against what the political branches are doing. And I think we have to remember, one of the phrases coined by IJ long ago was judicial engagement. We need judges to engage in the facts and utilize the Constitution to strike down those laws that are antithetical to individual liberty.
Well, those are two very important points for people to take away, and I thank you for sharing them. We can't wait to hear what happens with the cases that you're literally waiting to hear on right now from the Supreme Court. And we're going to be cheering you on as you take those forward. I was reflecting on this orchestra analogy and thinking to myself, sure is an orchestra, but you know what? Somehow it's one without a conductor, and it works beautifully anyway. So
spontaneous order.
Yes, spontaneous order. Yeah. Thank you to both of you for coming today and sharing about those cases. I hope people will follow your work and follow, the news about what happens next. And I look forward to talking with both of you again.
Thank you, Debbie.
Thank you, Debbie.